Legal analysis of all caps person, UCC payment theories, and tax myths. 1. Executive overview. You asked whether claims about an all-caps corporate persona, promissory notes that pay debts, and opt-out tax tactics withstand serious legal scrutiny. You evaluate them against black-letter law on personhood, negotiable instruments, legal tender, licensing, and tax procedure, and you find they are false or dangerously misleading. Footnote. You are assessing sweeping claims that collapse under basic statutes and settled doctrine. 2. Legal identity and the all-caps corporation myth. You are not a public corporation created from your birth record because your name appears in capital letters on forms. Typography does not create a separate legal person. Government records may reference you and they may also reference legal entities like corporations or trusts, but mere formatting does not transform a living person into a corporation or trust. Footnote. You reject the premise that style of print determines legal status. 3. Social Security numbers and INs. You understand that a Social Security number identifies an individual for benefits and tax reporting, while an employer identification number identifies a business entity or trust. They are distinct. Treating your Social Security number as an IN for an imagined corporation of your name is legally baseless. Footnote. You separate individual identifiers from business identifiers rather than conflating them. 4. Birth certificates and 2 birthdays. You recognize a birth certificate as a vital record, not a security or a title to a corporate persona. It evidences facts of birth and does not create tradable equity or a negotiable claim. No statute quietly converts you into collateral through your certificate of live birth. Footnote. You treat vital records as evidence of fact, not as financial instruments. 5. Jail is escrow and consent by wordplay. You reject the claim that jail is an escrow for a contract you can avoid by word formulas. Criminal custody is not a commercial escrow and courts do not release defendants because they say they are only attorney in fact for an all-caps entity. Footnote. You note that criminal procedure turns on charges and statutes, not semantic tricks. 6. Negotiable instruments and UCC basics. You read Article 3 to mean a note or draft can be a negotiable instrument, but you also read that private tender does not force a creditor to take non-cash paper outside agreed terms. Refused tender can affect interest from the date of tender, but it does not erase principal or compel a lender to accept homemade paper as payment. Footnote. You distinguish interest consequences of tender from cancellation of debt. 7. Legal tender and payment. You recognize that United States currency is legal tender for debts public and private and that parties can also agree on other forms of payment. You cannot unilaterally rewrite a mortgage, utility bill, or judgment by mailing a self-styled promissory note and declaring the account discharged. Footnote. You accept that payment must follow statute or contract, not unilateral declarations. 8. Mortgages, car loans, and the blank endorsement story. You understand that signing a loan application or note does not secretly fund your own loan at a window where a lender swaps your signature for cash. A lender's funding comes from its lawful sources and your note is your enforceable promise to repay under the contract you signed. Trying to retitle the note with add-on legends after the fact will not void the lien. Footnote. You treat loan funding and collateral as governed by the written contract and state law. 9. Taxes, voluntary compliance, and Fifth Amendment claims. You read the system as administratively built on self-assessment, but not optional. You cannot avoid liability by refusing to file, by writing accepted, or by sending promissory notes. Invoking the privilege against self-incrimination does not excuse wholesale non-filing and misuse of forms draws penalties and potential criminal exposure. Footnote. You distinguish administrative self-reporting from an election to opt out. 10. W9, W8, and revocation of election. You note that a W-9 certifies you are a United States person for information reporting and backup withholding, while W-8 forms are for non-resident payees. Filing a W-8 when you are a United States person or mailing a homemade revocation of election does not convert you into a non-resident for tax, and false certifications can trigger sanctions. Footnote: you recognize that misusing withholding certificates creates legal risk, not immunity. 11. Licenses, domicile, and travel claims. You reject the idea that a driver license is a slave badge or that you can lawfully drive without licensing, registration, and insurance by declaring yourself outside a state. Operating a motor vehicle on public roads is regulated and courts routinely uphold enforcement. Footnote: you place road use under valid police powers rather than private contract theory. 12. United States is only in the District of Columbia and income is undefined. You understand that federal jurisdiction and definitions span statutes that apply nationwide, not only within a small geographic footprint, and that income is defined and elaborated across many provisions. Claiming that no one knows what income means or where the United States is located does not defeat jurisdiction. Footnote: you read statutory definitions as controlling despite internet myths. 13. Litigation and criminal exposure. You see that mailing pseudo-financial instruments, clouding titles, or filing false forms can expose you to fraud counts, mail offenses, contempt, and fee awards. Courts have sanctioned similar tactics repeatedly and reliance on them often makes positions worse. Footnote: you treat these schemes as high-risk pathways to penalties, not relief. 14. Practical guidance. You protect yourself by reading your contracts, keeping communications in writing, and using dispute avenues the law actually provides. You consult licensed counsel for debts, taxes, or criminal matters, and you avoid anyone selling secret phrases, special endorsements, or pay your mortgage with a note kits. Footnote: you favor real remedies over scripts and seminars. 15. Conclusion. You conclude that none of the highlighted claims create enforceable rights or defenses. You ground your actions in statutes, case law, and written agreements, and you treat typography myths and UCC wordplay as legal dead ends that can harm you. Footnote: you end by choosing evidence-based strategies over debunked theories.